As social media giant Twitter takes on the center in the Karnataka High Court over the numerous orders to take down content under Section 69A of the IT Act, it has been allowed to place in court the center's blocking orders in sealed envelopes. The next hearing is scheduled for August 12. So, what exactly is Section 69A of the IT Act that empowers the government to block content?
The power to block websites or any kind of digital information is there with the central government under Section 69A of the Information Technology Act. This power can be exercised by issuing an order by the central government through the Ministry of Electronics and Information Technology and a blocking committee which is constituted specifically under certain procedural rules. These are called the blocking rules of 2009. And this power essentially can be exercised when there are certain conditions that can be satisfied which match with the reasonable restrictions under the Constitution of India. For its non-compliance, if an intermediary does not then block access, which can even be an internet service provider such as Airtel or Jio, which will block a website if it receives an order, but if it does not do so, or it may be an online intermediary which is a social network like Facebook, which is like Twitter, which does not do so, then a criminal prosecution can be started against them, which can lead to an imprisonment of up to 7 years.
The microblogging site in its plea has not challenged Section 69A of the IT Act. What it is saying is that the government's numerous orders show disproportionate use of power.
They are not challenging that the central government cannot issue a power for blocking, but they are saying that the way it's being done and how it's being done is legally unjustified. The first thing which needs to be there in order are reasons. Why is the government directing a specific website or URL to be blocked, right? So it needs to have those kind of details which are available. It needs to give a notice to the person whose website or Twitter handle or Facebook account is sought to be blocked, and that person should be given an opportunity of a hearing because it has a legal impact on them. And finally, when the order is issued to an online intermediary, it needs to be limited. It needs to only cover the illegal speech. So what has Twitter said with respect to its own platform is that the central government's orders do not have reasons. They do not give notice prior to the order and an opportunity of a defense to the individual user. And finally, the order which is issued and directed against the Twitter accounts and sent to Twitter for compliance is against the account itself, which can have about 24,000, 30,000 tweets. So the government wants to close down the entire account when a large portion of the speech, the 20 to 30,000 tweets may be legal, may be completely fine, but 1 or 2 tweets itself may be illegal. So it essentially is a disproportionate exercise of the blocking power by itself.
Apart from the effect the center's blocking orders have on Twitter or other social media platforms, the people who are most directly affected are those whose accounts are blocked or whose tweets are removed. And more importantly, no reason is given to the users for the action. On the other hand, there are other factors like fake news, rumors, online abuse of individuals, etc., where the government's intervention sometimes becomes necessary. So, where does one draw the line?
Every day, somebody or the other is at the receiving end of online abuse, quite often who happen to be vulnerable sections of a society, more often than not women, right? So you do need a form of regulation. You do need certain powers which are there with the government where it can restrict hate speech, etc., and other kinds of types of illegal speech by itself. However, this process of censorship needs to be transparent, it needs to be reasoned. Thereby, it will prevent, if these kind of checks are in place, that any kind of political purposes creep into the process of censorship by itself and restriction. So, a much more constitutional ideal can be maintained. These are broad principles, and any person who is watching this will say, well, this can't actually happen on a day-to-day basis, it's very difficult to implement. Well, it is fundamentally easy to implement if we just go by these principles and put them in our law. But does Section 69A actually reflect it? And that's the larger question. Secondly, one thing which is also very important to consider here is that there have been documented instances where people whose websites have been blocked, it has been found that the government did not have power to block those websites. For instance, there's a journalist Manoj Mehta, and he wrote a cover story, in fact, in the Times of India, that the popular adult comic Savita Bhabhi was blocked by the Ministry of Electronics and IT, relying on Section 69A, whereas Section 69A cannot be used for blocking any kind of obscene or pornographic content. That power is not there. So when you give the government power by itself through action which is not there in the law, it will then try to block other things as well, not only pornography or obscenity. So this kind of scrutiny is very much necessary.
So, while Twitter itself has not challenged Section 69A, does it mean that there is no issue with the law itself, but only with the way it has been implemented?
Section 69A, to a large extent, is a law which requires legislative reform. And this is needed because there's a complete lack of transparency in the orders issued by the blocking committee through the central government and sent to the department, sent to the internet service providers and social media companies, because it does not involve members of the public. So it is an order in which a finding is reached by a government department and the order is sent directly to a company. But what is it impacting is the availability of information on the internet. A website being blocked prevents people who are ordinarily accessing that website from accessing it. And this may not be only because that website is having something which is obscene, pornographic, infringing somebody's trademark or copyright. What we have found through our work regularly is that it's quite often touching on themes which may be unpopular or may not be congratulatory of government policies. And in any democracy, we increase our foresight. We become better societies when we know the risks and the benefits, and this plays a very important role. Section 69A takes away any engagement from the public, any remedy from the public for these injuries to their freedom of speech and expression.
Whatever the outcome of the legal course between Twitter and the government, it is certainly going to impact a large number of end users. A Times Online report.